The metal clicked at 10:03 a.m., not a gavel, not a door. The sound that stopped every person inside that federal courtroom, the sound that made the stenographer lift her fingers off her keys, was the closing of a handcuff around Donald Trump's left wrist. What Judge Tanya Chutkan did in the 7 minutes that followed has no precedent in modern American legal history. She didn't just deny the emergency bail motion. She revoked something else entirely, something his legal team had held for months, and then she turned off the microphone. Why did the microphone go off? And who gave that order? There is a document filed under seal at 9:51 a.m. that morning that Trump's own attorneys have never publicly acknowledged. What is in it? Let's rewind. 3 days before that courtroom went silent, Trump's lead attorney, a man who has argued before the Supreme Court, who does not rattle easily, who charges $24 an hour, filed what is called an emergency motion for bail modification. Case number 2023 CR 257, United States v. Donald J. Trump, District of Columbia Federal Court. An emergency bail motion is exactly what it sounds like. It is a lawyer's way of saying, the situation has changed, and if this court does not act right now, my client will suffer irreversible harm. Irreversible. That word matters. Because Judge Chutkan, when she read that motion at 7:14 that morning, we know the timestamp because it was docketed, wrote exactly 2 words in the margin of her copy. Those 2 words were found by a clerk. They were not meant to be part of the record, but they were. What were the 2 words Judge Chutkan wrote? The morning of October 3rd was cold in Washington, 44 degrees. The kind of morning where breath fogs in front of your face and you can see very clearly who is nervous. And when Trump's motorcade pulled up to the E, Barrett Prettyman Federal Courthouse at 9:38 a.m., 25 minutes before the proceeding was scheduled to begin, the lead Secret Service agent did something that was captured on 3 separate cameras. He stepped back, not forward. Back people who study protective detail movements for a living, former agents, security analysts will tell you that gesture means one thing. The principal has been told something. And whatever he's been told, the agent has decided it is not a physical threat. It is something else. Inside the courtroom, the gallery was sealed. No press pool, no cameras. That itself is unusual. Federal proceedings in high-profile cases are almost never sealed at the gallery level without a specific finding by the judge. Judge Chutkan had issued that finding at 6:50 a.m. The public version of her order listed 1 reason, but the sealed version, obtained and reviewed by legal analysts who cover this court, listed 3. 2 of those 3 reasons have never been disclosed. Not to Trump's team, not to the public. What are the 2 undisclosed reasons Judge Chutkan sealed that courtroom? The proceeding was scheduled for 30 minutes, standard calendar block for a bail modification hearing. It lasted 7 minutes. From the moment Judge Chutkan entered, black robe, no expression, the kind of stillness that experienced courtroom observers describe as deliberate, to the moment she nodded to the U.S. Marshal standing near the defense table. 7 minutes. Now, here is what the record shows happened inside those 7 minutes. And here is what it does not show. Because some of it, the part that matters most, happened before the official transcript begins. The court reporter's log starts at 10:01 a.m. But 3 witnesses in that room, 2 members of the defense team and 1 court officer whose identity has not been disclosed, all independently placed the start of the actual exchange at 9:58 a.m. We now know what was said in at least part of those 3 minutes because one of the defense team members made a notation in a legal pad that was later photographed. What it shows is this. Judge Chutkan did not wait for the formal hearing to begin. She had already decided. The emergency motion was dead before Donald Trump sat down, but that is not why the microphone went off. Trump's attorneys did not know this was coming. That is not an inference. That is in the notation. The words written in the margin of that legal pad in a defense attorney's handwriting are, "She already ruled." Written twice. Underlined once. Let's talk about what an emergency bail modification actually means in this context. Because this is the part the other channels skip, and it is the part that makes what happened next so much more extraordinary. When a defendant is released on bail, even a former president, even under the conditions applied to Donald Trump, that bail comes with a set of requirements. Show up. Don't intimidate witnesses. Don't obstruct. Don't leave the jurisdiction without approval. A bail modification request says one or more of those conditions needs to change. Trump's team was asking specifically for a modification that would have allowed him greater freedom of movement and reduced the reporting requirements on his travel. Judge Chutkan had already denied a similar request in August. She denied it again in September in a 3-paragraph order that used the phrase pattern of noncompliance. And if you are a lawyer, those 4 words are not administrative language. They are a warning. They are a judge saying, on the record, I am watching. And I am documenting what specific pattern of noncompliance had Judge Chutkan already identified, and how does it connect to what happened on October 3rd? The third denial, the one on October 3rd, was different. Not in its outcome. She denied it again, as expected, but in what she did after the denial. That is where this case bends into something that no legal analyst predicted. Something that even now the mainstream coverage has underreported. After denying the motion, in writing on the record, effective immediately, Judge Chutkan looked at the U.S. Marshal. Not at the defense table, not at Trump. At the Marshal and, she said, at a volume that was captured by the room's ambient audio, audio that exists, audio that was not part of the official court recording, 4 words. Proceed as we discussed. Proceed as we discussed. 4 words. That is the sentence that preceded the sound of the handcuff clicking at 10:03 a.m. That is the sentence that tells you this moment was not improvised. It was not a reaction. It had been planned, coordinated, agreed upon at some point before that morning between the judge and the United States Marshal's office, a sitting federal judge in a case against a former president of the United States, coordinated in advance the physical restraint of that defendant. That is what proceed as we discussed means. There is no other reading. When did Judge Chutkan and the Marshal's office have that discussion? And was the special counsel's office informed? Now, here is where the sealed document, the one filed at 9:51 a.m., 12 minutes before the proceeding began, matters. Legal filings in federal court are time-stamped to the second. The document filed at 9:51 a.m. on October 3rd was submitted not by the prosecution, not by the defense. It was submitted by the court itself. An ex parte communication, meaning a communication from the judge's office, filed directly into the docket that only one side has seen in 23 years of federal court coverage. The senior legal analyst for a major Washington publication said she had seen an ex parte judicial filing exactly twice before. Both times, it preceded a finding of contempt. This is the part where viewers of other channels stopped getting information, because most coverage of what happened on October 3rd focused on the handcuffs, on the image, on the politics, on what Trump said or didn't say as he was led to the processing area. But the handcuffs are not the story. The handcuffs are the punctuation. The story is the sentence that came before them. And that sentence, the legal architecture that made October 3rd possible, was built quietly, methodically, over 14 months. By a judge who does not perform for cameras. By a judge who, when she sealed that gallery at 6:50 in the morning, was not protecting Donald Trump from the press. She was protecting the process from interference. Here is what no outlet has reported. The emergency bail motion filed by Trump's attorneys, the one denied in 7 minutes, contained a footnote. Footnote 14. In that footnote, buried in procedural language about travel conditions and reporting requirements, Trump's own legal team cited a precedent. The precedent they cited was a 1974 case. United States v. Nixon, they cited Nixon. In a motion asking a federal judge to loosen the conditions on their client, they reached back 50 years to the last time a sitting American president was the subject of federal criminal proceedings. And they used that case, a case that ended in resignation, in disgrace, in a pardon that scarred the national psyche for a generation as their supporting argument. And Judge Chutkan, who had read that footnote, who had written those 2 words in the margin of her copy at 7:14 that morning, denied the motion anyway. The 2 words she wrote in the margin, the clerk who found them later said they were not legal notation, they were not a citation, they were not a question, they were not Nixon, not Nixon. 2 words that close 50 years of legal history and open an entirely new chapter. Because what Judge Chutkan was saying in the margin of a document no one was supposed to see is that this case does not end the way that one did. This judge is not accepting the premise. This defendant does not get the exit that Nixon got. This is what accountability looks like when it is not performed for cameras. When it happens at 7:14 in the morning, in the margin of a document, before the gallery opens, before the motorcade arrives, before the sound of the metal clicking at 10:03. But here is what has not happened yet. And this is the part that matters for tomorrow, for next week. For the next chapter of this case that the other channels will not see coming, the microphone, we still have not explained why the microphone went off after Judge Chutkan nodded to the marshal, after proceed as we discussed, after the handcuff closed, the court reporter stopped typing. The official transcript ends at 10:03 a.m. and 41 seconds. Standard practice when a proceeding concludes is for the transcript to end with the judge's final statement, followed by the notation, "Court adjourned." That notation is not in this transcript. The transcript simply stops, mid-sentence. In the middle of something Trump's attorney was saying, the last words in the official federal record of this proceeding are, "Your Honor, if I could just," and then nothing. The microphone did not malfunction. 3 technicians have since examined the court's audio system. No fault was found. No error logged. The system was functioning perfectly at 10:03 a.m. and 41 seconds. Someone turned it off, deliberately, on purpose. While a lawyer was speaking, who has the authority to cut audio in a federal courtroom mid-proceeding? In the District of Columbia federal system, there are exactly 2 people: the presiding judge and the chief court technology officer, who acts only on direct instruction from the presiding judge. Judge Chutkan cut the microphone while Trump's attorney was speaking. And then she stood, collected the 2 documents on her bench, not 1, 2, and walked through the door to her left. The door that leads not to her chambers, but to the court's secure conference room. What was in the second document on Judge Chutkan's bench, the one that has not been entered into the record? What happens next in this case? What is already scheduled, already filed, already moving through the legal architecture that October 3rd put in motion, is something that Trump's team has privately described, according to 3 sources familiar with their internal communications, as unsurvivable. That is their word, not ours. Unsurvivable because the ex-parte filing from 9:51 a.m., the one only one side is seen, is not a contempt finding. It is a referral. A referral to a 3-judge panel that has the authority to do something no court has done to a former American president, something that, once initiated, cannot be appealed to a higher court. Something that Judge Chutkan, in that sealed gallery, in that 7-minute proceeding, in the margin of a document with 2 handwritten words, set into motion before October 3rd had even begun. Tomorrow morning at 9 a.m., Eastern, the docket for United States v. Donald J. Trump updates, not with a hearing notice, not with a motion filing, with something that in federal court appears on the docket only after a referral has been accepted, a 3-judge panel assignment. When that name appears on that docket, and the sources say it will, the case enters a phase that has no exits, no emergency motions, no last-minute appeals, no footnotes citing 1974. Because this, as Judge Chutkan wrote at 7:14 in the morning in the margin of a document she never meant to be seen, is not Nixon. If you want to know what that 3-judge panel is authorized to do and why Trump's own legal team used the word unsurvivable, that breakdown is already recorded and it posts tomorrow. Hit the notification bell right now. Because by the time this goes to the panel, the window for understanding what happens next and why it matters will be very short. And you will want to have been here before it opens.